All right. So today we have an incredible presenter, Dr. Samantha Hardy. Now she is in Australia, so she very generously has allowed us to show a recorded presentation for today's Will Work for Food. Samantha Hardy is gosh, a real thought leader in our industry. She provides coaching, conflict support, training to managers and leaders around the world. We're really very lucky that she agreed to do this program for us, especially on short notice. But her contributions to this field have been widely recognized. She's received Resolution Institute's Award for Service for Dispute Resolution, for her leadership, for her innovation. She was named Conflict Coach of the Year in 2023 for the Australian Dispute Resolution Awards. She holds a PhD in law and conflict resolution. She's got postgraduate qualifications in adult education. And she, of course, like a lot of nerds that I really deeply love, she is committed to expanding her education. So we're really, really pleased to have her present for us today. And as you know, if you've attended these programs before, maybe you're new and you don't know, but the way Will Work for Food works is that all of these programs are offered for free. You can attend any of them, you can attend all of them. And then if you're able and can make a contribution of time or money to your local food bank or the food bank that is supported by our presenter, it's greatly appreciated. And of course, let us know if you make a contribution so that we can add your contribution to the running total. And David is going to share with us just exactly how generous our presenters, teammates, and of course, audience have been.
Thank you, Natalie. It's my pleasure. As of today, we have been told about donations totaling $1,024,592.09. Just an extraordinary testament to the generosity of everyone involved in our audience as well.
That is a stunning number. Thank you, everybody who's made a contribution as a speaker or an audience member or a contributor to a local food bank. All right, I'm going to put Samantha's preferred food bank in the chat. She would like for us to support Food Bank Australia. So if you're able, click on that link and let us know. And now I'm going to share my screen so that we can watch what she has recorded for us.
Part of the reason that I'm doing this presentation today came from former students, graduates who I've been mentoring, asking questions about support people. And there is this kind of assumption, which is written in a lot of policies that I'll mention, that you can only use support people in certain ways in certain parts of the process. And it's just, yes, that's the norm, but it doesn't mean it's the only way you can do it. There's actually quite a bit of flexibility. You just have to be really clear about some guidelines. So being me, I went and did some research around what different policies existed in Australia, and I looked at a couple overseas as well. But I guess I wanted to broaden our ideas about support people, because what I found was actually pretty narrow. And I couldn't find a really good justification for it. So as usual, I'm challenging you all to think about this in a slightly different way. All right, so let's get going. This is what we're going to talk about. Who support people are, or who they could be. What sort of people might be asked to join as a support person. I'm going to give you a framework for thinking about the role rather than just this general instinct or this, that's the way we've always done it sort of approach. What you need to consider before a mediation, during a mediation, and after a mediation when you do have support people involved or there's been a request for a support person. I'll briefly talk about what the published guidance says. I won't go through every single document, but I'll give you two extremes, I suppose, from the spectrum of what support people policies talk about and allow. I'll give you some recommendations. I'll briefly talk about how things might be different in a coaching context as opposed to a mediation. And I'll give you some practical tools. In particular, I've got a checklist of questions to consider when you've been asked about a support person being involved. It's I've basically made it up. So it's by all means not the definitive guide, but it might be a prompt for you to reflect on the role of support people, and feel free to work on it, improve it, adapt it to fit your circumstances. Okay, so here's the key question. Can the process, and we'll talk about mediation to start with, but you can transfer in conciliation, arbitration, coaching, whatever you like. But can whatever process we're running genuinely serve the person without a support person? So that's our fundamental question. Could they participate without a support person, or is a support person really needed so they can get the most out of the process? That's our first question. And we might not know definitively the answer because we're not therapists. It's not actually a straightforward question to answer, but that's one of the things that we want to try and consider. A slightly different way of asking the same question: is a support person required to provide that participant with access to self-determination? Is the support person going to give them more capacity to make choices, to process information and make decisions in the process, or not? Again, we never know this definitively, so this is a bit of a value judgment, but there are some criteria I think we can consider. Okay, so why might parties want support people? Well, if we're talking about mediation, for example, it's unfamiliar. It's a pretty stressful experience. If you're going in to have a conversation with someone that you're in conflict with, it's not a comfortable situation. It always feels good to have someone who's got your back or is giving you some sort of moral support. It might also be that we talk about mediation being kind of a flexible process, and it's a chance for people to talk about what they want to talk about, and we're going to help them, come up with an outcome that maybe they can live with, or something along those lines. That might feel quite disorienting to people who don't really understand what's going to happen. Even though we might tell them about the process steps, they might not be really clear about what that means. And they might be very nervous about going into a process that they've never been in before, and they just don't know what capacities they might need or what cognitive type processes they might be asked to engage in. And so they want someone there to help them just in case it gets too hard. It might also be that the person has a real need for support for psychological safety, and that they might not be able to participate without that support. They wouldn't feel psychologically safe to go into a conversation without a support person. And as mediators, we often think of the support person as a complication, like, oh gosh, now I've got to try and deal with this extra person. I'm going to have to try and get consent. I'm going to have to try and keep another person under control if they step outside their role. But keep in mind that sometimes a support person is actually what is required to enable a person to participate fully and safely. So I've identified three broad categories of the need for a support person. So there's some people who need it for emotional reasons. They might be incredibly anxious. They might be nervous about going into an unfamiliar process. They might feel very isolated. So it might be for emotional support. The second category is for participants who might be particularly vulnerable, and that might be because of some mental health concerns, some real or perceived power imbalances. Perhaps they're people who've experienced trauma in their lives or have some kind of disability that they're worried about how it might impact their participation in the process. The third category, and this is one I think we don't think about enough, but it's become quite apparent to me as I've been doing work around neurodiversity and things like accommodations or flexibilities. There might be a legal or an ethical necessity for a support person to meet our obligations under anti-discrimination legislation, to ensure that we're offering the parties procedural fairness, and it might be an access issue. So, for example, if we think very broadly about who a support person might be, they might be a translator, for example. In one sense, a translator is a support person for the person who doesn't speak the language of the other two people. They can't participate without that translator. And we don't often put a translator into the category of support person because, in a sense, the translator is providing support to the mediator and the other party as well by translating that information. But it is another person in the room who provides access and communication support for the person who doesn't speak that language. So who are the types of people who might be asked to be a support person, or who your client might want to be a support person? Often it's a family member or a close friend, particularly if we're looking at that emotional support side of things. They just want somebody who, they can lean on, who makes them feel a bit safer. It might be someone like a union representative or a workplace delegate. That can be a little bit tricky because usually those people come with their own, I was going to say baggage, but that's a bit derogatory, but with their own values and motivations for being there that might go beyond supporting that individual. It might be a lawyer or a legal advisor. Again, we don't often think of them as a support person, but they are. They're a particular type of support person and they're there to support their client. It might be a coach. It might be someone like a conflict coach or a divorce coach, maybe even a life coach. It might be an advocate, and in disability conflicts, often the person will come along with an advocate. It might be a disability support worker. So, for example, if we have someone who's non-speaking but has a communication partner, then that communication partner might be there to help the non-speaking person verbalise what it is that they want to say. In some situations, it might be appropriate to have a cultural elder or a community representative, and there are also particular criteria and considerations when that's the sort of support person who's being suggested. And sometimes, particularly around restorative justice type processes, it might be a caseworker or a social worker who's involved in, say, supporting a young person who has committed a crime and they're going through some sort of restorative process. What each brings and what some of the complications are. So a family member or a close friend does bring emotional safety and familiarity. There's someone that the client knows well, so that's usually a good thing. However, family members have pretty strong views. They might have their own agenda and they may not have any process knowledge. They may never have been to mediation before, so they might not know what's appropriate and what's not appropriate for this setting. And even though they might be there to support their family member, they might have strong opinions about their family member. They might hear information about their family member that shocks them or doesn't surprise them, and their interest might get in the way of effectively running the communication between the person they're supporting and the other side. The union reps and workplace delegates, they're pretty good because they do tend to have knowledge of the process, not always, but usually those sorts of representatives have been through this sort of process before. They understand the process. They usually understand the rules of their engagement and their participation. Whether they keep them or not is maybe a different thing. But again, they might have institutional or political agendas that might sometimes not align entirely with supporting the person who they're there with. So they may, for example, oppose some kind of agreement that works for the individual but isn't aligned with, say, the union's policy or political stance on that particular topic. Lawyers and legal advisors, again, they usually know the process pretty well. They have lots of information, lots of good legal advice that they can provide, but they can sometimes make the process more adversarial, move it into more of a positional bargaining negotiation, and that might not be the sort of mediation that the mediator and perhaps the parties are intending. Coaches can be very useful. They sometimes have process knowledge if they've been involved with mediation before, but there can also be some role boundary considerations. So, there's role boundary considerations with all of these. It's a little clearer where we're talking about lawyers or interpreters because they're professional support people who are usually brought in with very clear guidelines. And this is, I guess, a little bit of an aside, but it's one of the main points. All of these other people could potentially be brought in. The problem is that we don't have clear guidelines, or the guidelines that we have are very simplistic and don't allow for much variation or nuance. They're sort of one-size-fits-all rules for support people, and I think it doesn't have to be like that. We can have more diverse ways of including support people as long as everybody's on the same page. For this particular situation with this particular support person, these are where the boundaries lie and reasons behind that. The advocate is usually someone who speaks for the person. They usually have good content knowledge and good process knowledge. The challenge can be that they can go from being an advocate to a representative, which means that they're making decisions for the person rather than just speaking for them and then handing the decision back to the client. Disability support workers, particularly if they're a communication support person, can provide good opportunities for someone who might not normally be able to participate in, say, a verbal process like mediation usually is. But there have been concerns raised, much like with interpreters, that sometimes those communication partners can communicate more than what the person is asking them to communicate. So they can become more of an advocate, spokesperson, representative, rather than just a communication support. Cultural elders or community representation will come in with some cultural authority, some cultural understanding. If they're in a community representative role, they'll have some good knowledge about that aspect of the situation. And many of those people will expect a speaking role, particularly in some of the cross-cultural contexts. And that can be a problem given that most of our policies say support people shouldn't speak. So sometimes they can be culturally insensitive. And then caseworkers and social workers can be very useful because they have a wider understanding of the person and the person's context and needs and what might or might not be feasible in terms of agreed outcomes. But again, they usually represent an agency. They usually have purposes or values or interests that may not always align entirely with the client. So I want to introduce, not in person, she's not here in person, but this is my friend Olivia Rundle. She was a colleague of mine for many years and I actually co-supervised her PhD. We have a webinar that she ran on lawyers' roles in mediation. And as I was preparing for this support person roles webinar, I thought, Olivia's model of the different roles lawyers could play in a mediation actually could be applied just as well to support people. I think her 5 models works really well as a way to look at the different ways that a support person might be able to participate. So again, the core insight from Olivia's work is the question isn't whether a support person, in her research it was a lawyer, but my broader adaptation, the question is not whether a support person is present, it's what role they will play and whether that is understood and agreed by everyone in the room. So these are the 5 roles that Olivia proposed based on her research. So she interviewed a whole lot of lawyers and mediators about the relationship between lawyers and mediators and their clients in mediation in the Supreme Court in Tasmania. It maps really well on what happens in most other jurisdictions in Australia. So the first role is absent advisor. So this is somebody who's not sitting in the room, but maybe literally sitting outside the room or maybe available on the phone, who the client can talk to throughout the mediation, maybe in a break, but isn't actually participating. So that sort of support person is not usually a huge issue. The issue starts to become more problematic when they want to be in the room. So this could be that they're not involved at all, or they're sitting in a room where the person goes for private sessions or for breakouts. The second type of role is the observer role. So they might be in the room, but not speaking at all. They just watch what's happening. And they could talk to the client outside of the room, but certainly not saying anything during the mediation. And this is probably the norm. This is the sort of standard support person role. But again, I don't think it's necessarily the only one. The third one is a resource contributor. So this could be, in a lawyer's sense, it might be when an issue starts being talked about and there's some conflict around what the value of this particular item might be, the lawyer might be able to say, I've looked at the case law and the value of this sort of claim is usually between $10,000 and $20,000. And maybe if there's a lawyer on the other side, they might say, well, I think it's $15,000 and $20,000. But they're not actually engaging in the discussion, in the negotiation, but they're providing information when it's relevant. And other type of support people might be able to provide information, not legal information, but they might be able to provide information or resources that support the conversation without actually being part of the conversation. The third version is the active participant. So this is where the support person and the client act as a team. So they will talk together. They might take turns in speaking. They might both speak at different times. The client might say something and the support person might add something, or the support person might say something and the client might clarify it. So they're acting as a team. It's a collaborative effort. And then the bottom version is the spokesperson, which is the least likely with a non-legal support person, but in fact is the most likely for a legal lawyer support person. And that's where the support person talks on behalf of the client. One of the best lines in Olivia's PhD research was when she was interviewing a lawyer who represented clients a lot in mediation. And his famous line that he used to say to his clients was, "You hired me as your bulldog, so you don't need to bark." He wanted his clients to sit there and be quiet and just let him do his barking, do his job, which maybe works in some situations, but is probably not always the ideal way to do it. Olivia set these or identified these roles in practice with how different lawyers participated in mediation. And I think we can use these models for any kind of support person, and we can use them to talk with a client about these are the different ways that a support person might be able to support you. They might be an absent advisor. They might be available on phone. They might be sitting in the private session/breakout room. They might be observing. They might be able to participate in a very limited way to provide information or resources at certain points in the process. They might be able to be an active participant so that you could work together and speak together in a way that works for both of you. Or they could speak for you. Now, I'm not saying any of these is better or worse. It might depend very much on the situation, the type of conflict, the type of support person, and what the other party feels about it, because that's obviously a very important part of this equation. So the absent advisor isn't in the mediation room, is available before the session, during breaks and after, perhaps also in private sessions. But in some cases, they're not. When the mediator goes to talk to the party in private sessions, they'll require the support person to leave. So they're technically not in the private session or the mediation, but they can talk to the client at any other time. I think there's a little bit of room for variation there. Generally speaking, an absent advisor is providing emotional steadiness, preparation, support, and debrief. Could be a trusted friend, could be a conflict coach, could be a lawyer. And the reason perhaps those people would not be allowed in the room is that they might shift the dynamics in a way that's problematic. Keep in mind that in certain circumstances, they might shift the dynamics in a way that's helpful. It's often the most appropriate arrangement in coaching. It's not usual to have a support person in a coaching session. But again, I don't think it's necessarily a problem. You'd have to ask some questions about, would the client be as open with the support person? And that obviously would depend on the support person's role and their relationship with them. The observer, this is a standard model of support people. Present but silent. Witnesses what's going on, provides a calming presence by proximity, is available to the party during breaks, works well when the party's primary need is not to feel alone, but does require the support person to genuinely understand and commit to the constraint of not speaking. And I'm sure we've all been in situations where you've had a support person who's not supposed to say anything and they can't help themselves and they blurt something out, and then you have to manage that challenge. Practically, it can be very difficult for a support person, particularly if they're invested in the person they're supporting's outcome, to just sit there and be quiet. And I guess that's another question when you're evaluating whether this support person should be present in the room or not, is their capacity perhaps to be able to remain silent and how invested they are in an outcome which might work against the client's effective participation rather than supporting it. The resource contributor, again, present, contributes specific knowledge, but at bounded moments, only when specifically requested to share information. It would usually be at the practitioner, so the mediator's invitation, or with the mediator's agreement. Some examples might be a disability support worker clarifying someone's communication needs, a cultural elder providing context for a particular situation or behaviour, maybe a conflict coach explaining a process concept to a client. Contributions are specific and really quite carefully boundaried, not ongoing and not open-ended. And generally speaking, the practitioner would be the one who would manage when and how these occur. The active participant is more interactive. They might help the party articulate their position. They might be able to help translate complex information to or from the person they're supporting. They might be able to help the person process, contribute in ways that are facilitative, not directive. So they're meant to be working with the party, not telling the party what to do or what question to ask or what decision to make. It is important in this role that the party themselves remains the decision maker and the primary voice. And this model does require the clearest upfront agreement and the most attentive management, because this is where things could get a little bit out of hand. So you need to have very clear guidelines, and as a mediator you need to have very clear ideas about what is going to happen if this doesn't seem to be working as intended. And again, these are the things that we don't often prepare very well for. They happen in the room and then we're having to sort of wing it in the moment, but thinking about these things in advance and having some scripts or some ways to manage, support people getting a little bit out of hand can make us a lot more confident when those things arise. And the spokesperson, what's important here is the spokesperson isn't the representative. So they are not making decisions for the client, but they may be speaking for them in the mediation. But it's important that there's a distinction here between a spokesperson and someone who makes the decisions. The party remains the person who's signing the agreement, and the spokesperson should be checking in regularly, and that's something you can keep an eye out for as the mediator. It can be really useful when there are genuine barriers to direct communication, for example, disability, trauma, language, or power dynamics. And again, it requires explicit agreement from all parties and the practitioner. These models are not a hierarchy from acceptable to problematic. Each of these might be appropriate in different circumstances and unsuitable in others. So the spokesperson model isn't a last resort. It's not the one we do only in, the most extreme circumstances. For some people, it might be the most appropriate choice. The issue isn't which ones are permitted and which ones are not. It's which one's most suited to this situation and what are the clear guidelines, boundaries and responses for how that might work in practice and what might go wrong, I suppose. One of the questions that always comes up is what happens in intake? Do you do intake with a support person? Does the support person come along to intake? Do you do intake with them together? Do you do intake with them separately? I think it is important, if you can do it, to meet the support person in advance, because you're going to get a bit of a sense for whether or not they're going to be able to fit a particular support person role. You're going to get a bit of a sense of whether they're likely to say something when they shouldn't, or they're invested in their own interests. That's the sort of thing that I think is important to identify. I think the other challenge is you need to, if possible, meet with the client individually. And ideally, you do that first and the support person second, but if the client wants to come to intake with their support person, that might not be as easy to do. But I think at some point, if you can, if the client agrees, it's useful to talk to the client separate from their support person, just to make sure that they agree with the support person's perception of their role, and also to check for any kind of risks, that there's not coercive controlling behaviour, that the support person isn't actually trying to push the client into doing something that maybe they might not be comfortable with. So in an ideal world, and you are going to have to negotiate a little bit with the people involved, you would talk to the client first without the support person, primarily to assess the need for a support person, what the client imagines the support person is going to help them with, to discuss with them the different roles and check what the client's expectations are of which role might be most suitable for them, and to screen for any power issues, that the client's not being manipulated by a support person rather than supported by them. And have a bit of a conversation about the proposed support person's relationship to the party. Ideally, next, you would talk to the support person either separately or with the client. If you want to talk to the support person separately, I think you need to get the client's clear consent first. But I also don't think it's necessarily a problem to do that support person intake with the client present. If the client turns up at intake with a support person, you might do a little bit with both of them, and then you might suggest that you talk to each of them separately, hopefully get their agreement, talk to both of them separately, and then bring them both together again to sort of formalise the end of the intake. Make sure, whichever sort of support person you have, that they sign a confidentiality agreement. That's super important. Irrespective of which role they are, make sure that everyone's aware of that. Also, this is where it gets tricky. If the process is confidential, but one of the parties is discussing it with their support person or their support networks, it's not going to be confidential. So even if we've got an absent advisor support person, you have to be really clear that either that person signs a confidentiality agreement because they're going to be told a lot about what's happened in the mediation, or the other party agrees that the person that they're in the mediation with is going to talk to that person. So it's an exception to confidentiality. But it's always a risk when you've got a party talking to someone else. There's always a risk that person might talk to other people about it. So you either have to get the parties to all agree that that's okay, or even if it's an absent advisor, I don't think it's a bad move to have the absent advisor sign a confidentiality agreement. And I think that's particularly important if the support person works for the same organisation as the party. So sometimes in workplaces, they want to bring along a trusted colleague, or they want to have permission to talk to a trusted colleague outside of the mediation. So I think we need to think very carefully about confidentiality in those circumstances and whether or not you need a formal agreement, even if they're not in the room, if they're going to be given information about what is happening in the room, which is slightly different from that standard kind of confidentiality exception that is in some agreements. The one I saw recently was something like the parties can talk to people within their legitimate field of intimacy, or some obscure phrase like that, which basically means a close friend or family member. But again, there's a difference between sort of generally debriefing or actually discussing in detail what's happening in the room. And so I think confidentiality is something that needs to be discussed with all parties and the support person. Procedural fairness, to ensure that there is procedural fairness when a support person is potentially being involved, you need to discuss it well before the mediation. I think it's also important for, I guess, kind of inclusion purposes to treat a support person as an ordinary part of the process, not a special accommodation for someone with a special need. That can actually be discriminatory and a bit stigmatizing if you make it sound like, if you bring a diagnosis along, then we'll agree to have a support person. We need to, I think, to be more inclusive, say, everyone's entitled to bring a support person. There might be various reasons you might need one. You don't have to disclose specifics, but it might be helpful for me to understand the role that the person might want to play, and particularly important so that we have clear boundaries around what the support person is and isn't going to be doing in the room or outside of the room. Now, this is where it gets tricky, right? You have it all organised with your one client and their support person, and the other party says no. Okay. Now, this is a voluntary process, right? If we really practice what we preach, I know voluntary is kind of limited in some workplace contexts, but it is the other person's right to not agree to participate if the first party brings a support person. While that might not be ideal, and while they might be being discriminatory in that they're not allowing somebody who might have a genuine need for a support person to bring one, they can choose to be discriminatory or not. They can choose whether they feel comfortable or not. And I think we have to allow people the choice, even though sometimes that might mean the mediation doesn't proceed. It is something that someone's entitled to say no to for their own reasons. What we generally do is offer the other person the opportunity to bring a support person. And again, we have to go through all those processes with that person, and we have to ensure that there's consent on both sides. If someone does say no, I think it is worth having a conversation with them about what their particular concerns are and whether adjusting the role of the support person might make them more agreeable, or whether changing the specific person who's going to be the support person might make them more agreeable. So unpacking a little bit what their concerns are and seeing whether you can be a bit flexible about perhaps allowing a support person but in a slightly different way, or a different individual in that role that might make them more agreeable. What do you tell the other party? So someone's asked you for a support person, they're all clear, their support person's clear, but you've got to talk to the other party about it. What do you tell them? I think you need to disclose what's reasonably necessary for the other party to assess whether the process is fair and safe for them, and no more. I don't think you have a right, for example, to disclose the other party's mental health diagnosis if that's the reason for them asking, unless you have specific consent from the first party. But I don't think you can go and say, oh, so party A has told us that they have, I don't know, bipolar, so they need a support person to help with such and such. You might be actually disclosing information that is personal and private to that other party and is none of the other person's business. So you have to be cautious about giving them enough information to make a choice. But again, sometimes just sort of saying as a matter of fact that we offer everyone the opportunity for a support person, party A has chosen to take that up, and this is the general type of person that's coming along. Generally speaking, I don't think you need to tell the other person the person's name, qualifications. I don't think you need to give them a lot of information about the support person. There may be situations where that's important. So, for example, if it's a separating couple and the person wants to bring their new partner along as a support person, that's probably information that the ex-partner needs to know to be able to make a sensible decision. But if you provide too much information about, oh, this is a mental health support worker, you might be disclosing information that is private to the other person and not appropriate to share. So again, one of the things that you want to do with the client who's asking for the support person is get an agreement from them about what information you can provide the other party about why the support person is needed and who the support person is and what their role is. You might be able to say, they're a mental health professional supporting this person to manage their emotions. If they're a professional support person, you probably don't want to be providing names and addresses and qualifications. But again, that might be something that the other party might want to know. So you've got to balance the need for privacy and the need for the person to have enough information to make a choice. And again, you can't make people agree. You have to give them enough information to make an informed choice, and how much information they need to feel informed will depend a little bit on the situation and also what the first party's agreed for you to disclose. But be very careful about what you disclose unless you've specifically talked about it with that first client. You can reality test. If I don't tell them who they are, or if I don't tell them the reason, they may say no. Is there some other way we can address it to maximize the chance that they say yes? Because if they say no, I can't make them participate with this support person. I think I've already said this. I don't think you need to give the support person's full name and personal details. There might be situations where you need to, but generally speaking, I don't think you need to. I think you have to be cautious about telling the other person the reason they want support. You could just say, there seems to be a genuine need that this person could meet. Again, it's a bit of a sticky situation because some people will accept that and some people will want to know more. But be very careful that you're not breaching confidentiality from the intake, that whatever you do disclose, the first party is aware and has given you permission to disclose. If they say no, understand the objection, ask if there's a way to address the objection and still have the support person involved. Is there another way for both parties to have self-determination without support people involved? Could a change in format help? For example, going to a shuttle format rather than an in-person format, would that resolve some of the challenges that the person might be having about a support person? Whatever happens, record your decision and reasoning, because this is the sort of thing where complaints might be made and you might be asked to justify your decision. This is not about the substance of the conflict. So in a sense, you're writing down your procedural choices rather than writing down your perception on the substance of the conflict. So I think you're okay if you're careful about how you record this. And I think it's a good idea to do this, if only to cover yourself in terms of a complaint or an insurance issue later on. At the start of the session, introduce the support person explicitly and describe their role. Give an unambiguous statement, a clear statement of what their role does and does not include. Check that the other party is genuinely comfortable and not just tolerating it. So reinforce all of that right at the start of the session. And if things change, so if someone's acting outside of the role that's been agreed, you can reference back to that. As we agreed at the start of the mediation, the support person's role is, I've noticed that you've started to comment and that wasn't what the agreement was. If there's a significant reason for this change that we need to discuss, let's have a break. I'll talk to everyone separately. We can renegotiate the support person's role, but otherwise, depending on the extent of the boundary breach, you might be able to remedy it, or you might need to adjourn the mediation and perhaps restart at another time, maybe without a support person. You've got many choices at that point. So if things go wrong, if it's a single interjection, so the support person's not supposed to be saying anything, for example, and then they blurt out something. If it's a single statement and not systemic interference, maybe a gentle redirect might be appropriate. Thanks for that. I'd like to hear how the particular client sees it. If it continues, a private conversation with both parties and the support people to discuss the impact of what's happening and their choices about continuing or not. If it's serious or persistent boundary breaching by the support person, having a really explicit conversation about what might happen if the agreements are not respected. And that might be the mediator choosing to terminate or the other party choosing to terminate. The problem with these blanket rules that we tend to have around support people is that they have a sensible purpose at their origin, but the purpose gets lost in the rule and the rule becomes the rule. So this is one of the concerns I have about blanket policy saying you can have a support person if the other person agrees, but they're not allowed to participate. They're not allowed to talk. That doesn't necessarily support the person or this particular process. So we need to be a bit more open-minded about that. I had a look at policies and all of them require consent by both parties. Silent support is the default. So almost all the policies say a support person can be present, but they're not allowed to say anything. What I looked at was Legal Aid Queensland, Victoria Legal Aid, Dispute Settlement Centre Victoria, New South Wales and Northern Territory Community Justice Centres, Relationships Australia, the New Zealand DRC, Resolution Institute, and then the EEOC in the US. Confidentiality obligations are standard, and the mediator discretion to exclude a support person is also universal. So they're the things that are common in those published guidelines around support people. The most restrictive version that I could find, there may be more, is the New Zealand Dispute Resolution Centre Mediation Protocol. It says a support person is not entitled to intervene or participate in any other capacity whatsoever other than observing. If they wish to speak to the party must formally request a timeout from the mediator. So that's a pretty restrictive approach. Here's an example of the widest one. This is the US EEOC, Equal Opportunity Commission, Mediation and the Americans with Disabilities Act. So it frames support people as a reasonable accommodation, as an adjustment to enable someone with a disability to have full and informed participation. And it distinguishes roles like personal assistance, interpreter, and representative. And each of those approaches to having a support person is treated as a different arrangement with different implications. So it has a number of different ways a support person might be involved with different guidelines. And it anchors the question of whether the support person is allowed to the party's capacity to participate. So it's a case-by-case basis. It's not a blanket rule. It's not a general entitlement. Now, that is framed obviously within a disabilities framework, but as I've been saying a lot when I talk about inclusion, we should be offering flexibilities to everyone without them having to prove their entitlement to it by showing some sort of recognised disability. That actually is stigmatising, and it's not necessarily fair, because many people might have valid reasons for support and might have little or no opportunities to get a formal diagnosis, or they might have very good reasons for not wanting to share that with other people. So here's some recommendations. What I think we should do, and this is probably more for agencies than individuals, but if you work with your own kind of policy, here's some things to think about. Rather than having a general power to exclude support people, rather than it being the mediator's discretion, have a decision-making framework. Have some clear guidelines for when support people are allowed and what the different roles might be and what the boundaries of each of those roles might be. Also have a disclosure standard grounded in procedural fairness. So think about what needs to be disclosed to the other party to ensure procedural fairness, but not be unintentionally revealing information that might not be necessary. Look at the 5 model framework as a standard 5 ways that a support person might participate. You might choose only some of those that you are comfortable with in your mediation work, and that's okay. But I think rather than having the observer or nothing, there are some other options that we could map out in more detail and have guidelines around. I think coaching is a slightly different context, but it does relate to having a support person in intake or a pre-mediation session. So I think there's also room to think about the benefits and the detriments of having a support person in a coaching context, why someone might want that, and what that person's role might be in a coaching context. We could use the same kind of framework. It's obviously a little bit different because the client is just talking with the coach. You don't have another person or other people present. And I think we need to build cultural responsiveness into our decision-making framework and our possibilities framework rather than it being a special exception. Coaching, I just want to talk about this very briefly, but I think all the same principles generally apply. Obviously, you don't have to ask permission from someone else, so that helps, makes it simpler. The challenge, I think, is that coaching does depend on the client's willingness to think aloud. Coaching tends to be a verbal interaction, a verbal process of reflection and questioning. The idea is that the client surfaces assumptions that they haven't examined, sits with uncertainty, explores their situation from uncomfortable angles. Having another person in the room may well change what a client is willing to say. I guess the question is it helping them say more, think more, or is it potentially shutting them down? Is it potentially causing them to sanitize perhaps what they say rather than being authentic and transparent and honest, which maybe they're more inclined to do just with the coach? Obviously depends a lot on the relationship they have with the coach. If you're being coached in an organisational context, it might be a bit different. There might be a suspicion on the client about the coach's impartiality, non-judgmental support for them. There might be concerns about where the information might go. So again, the context in which the coaching occurs might make a difference to the perceived need for a support person and the perceived role of the support person. But I think it's something that's not just a minor consideration. We need to really think about whether the support person is helping the person participate or potentially getting in the way. And again, we're never going to know for sure, but there are some things that we can talk to them about to try and do a bit of an assessment on what we think is the most likely thing. And it might also be that the client needs to build trust with the coach, and once that's established, they may not need the support person anymore, and that might then open up opportunities for that deeper work. So again, it's not necessarily an all or nothing situation. When someone asks you for a support person, I think we also just need to think a bit more broadly about what that might mean. It might signal that they're anxious about the process, and that might be something we can address in other ways other than saying, yes, let's get the support person in the room. Even if we're still allowing a support person or the other party's agreeing to it, it might be something we can still explore as well as the support person. Maybe in a coaching context, it's expressing concern about the safety of the coaching relationship. And again, rather than bypassing that by saying, yes, have a support person, it might be worth explicitly having a conversation about that. It might also indicate a genuine vulnerability requiring some form of support. It might be some anxiety about communication. It might be some anxiety about cognitive processing. It might be some anxiety about emotional regulation. And those things are something that should be supported. And again, it's about tailoring a particular response to a particular client in a particular intervention. There shouldn't be an automatic yes or no. We should actually put a little bit of work in trying to decide what support is needed, whether it's possible, and how we can best frame it so that it increases the benefits that we're aiming for without creating other problems that might outweigh those benefits. Finally, I do have available for you, I'll put it below the recording, so you'll get a login to access the recording. This is just the front page of it, but there's a whole lot of questions to help you work through some of the challenges that you might face with a support person. So there's a few pages of questions. It's not going to say, then count up your answers, and if you've got over 8, then you allow the support person. If you've got below 8, then you say no. It's not that straightforward. But it'll give you some questions to reflect on and some questions to ask both the client, the proposed support person, and the other party to help you get a clearer idea of what decision might be most appropriate in this circumstance. I do also have a long list of references. There's the webinar on demand of Olivia's talk around lawyers, which is useful just to map out again those 5 different roles. The checklist will be below the video when you get your link to that. And all of these other ones are the policies. They're not all policies on support people. Some of them are information about how mediation works, but they include something to do with support people. So if you ever want to go and have a look at those in detail. The other thing I'd say just generally, even if you're working as a solo practitioner and not within an organisation, you might not think to have a policy on this, but I think it can be really worthwhile to have a policy, even if it's just for your own guidance. But I also think it's useful to make transparent to prospective clients. So you might have, for example, a frequently asked questions section on your website, and one might be, can I bring a support person? And that's where you could provide some of that information about the different support people roles, some of the things to consider, how the other person might be approached about that, and who makes the final decision. So I think, again, this is part of one of the things that I've been working on a lot lately, which is mediators being better at explaining to clients what we do and why, and what their choices are, and how those choices might be assessed and decided. I don't think there's a rule that you can't have a support person in intake, and there might be some very good reasons for having a support person in intake. If the person needs a communication partner, it might be essential. You might not be able to do intake without them. Or if they're very, very nervous and anxious about even the intake, then it might give them some comfort. I think in general, if someone asked me to bring a support person to intake, I would agree as a matter of course. But I would also say that probably at some time during intake, I would like to talk to each of them separately. And in that situation, I'd be doing a bit of an assessment about why the support person was involved and whether they were able to be a support person in whatever type of support person role. I'd be more inclined to agree in the sense that, I guess, if you say no, the client has a choice then whether they turn up or not. But my question is whether by saying no, you create a barrier to participation that maybe wasn't necessary, that maybe there was some exploration. Maybe you could have had a conversation with them both that made them decide that the proposed support person wasn't a good person to participate as a support person in the mediation, but at least they felt part of the decision rather than an arbitrary no. I guess that's my take on it. There may be particular reasons in particular cases not to do it, but I would say generally speaking, unless there's some incredible risk or problem, it can't hurt too much to have someone at intake, but I would try to talk to the client and the support person separately as well as jointly, just to make sure that there wasn't any kind of manipulation going on as best I could. This is my opinion, right? My opinion is, why wouldn't you allow someone? I don't think there's a rule that says you can't. There's certainly a kind of norm that it's not allowed, but I don't think there's a good reason behind it. So other people might disagree with me. I'm telling you my opinion. You can make your own decision. I think most people would say, oh no, you shouldn't allow it, but I don't know whether it's just because that's the norm. I suspect there's not always the right reasoning or enough reasoning behind it. I definitely don't think there's a rule that it's not possible. Technically, it could be a breach of confidentiality. Potentially, that could be a reason to stop the mediation. I guess there's also that distinction of, was the husband a support person or was the husband a close family member that she just happened to be chatting to? And this is why it's so important to try and be explicit about these things beforehand so that thing doesn't happen. Technically, maybe it was a breach of confidentiality if there was no exception. And she was talking about what had happened in the mediation. Yes, technically a breach, but everybody knows that almost everyone will go home and talk to their loved one about what happened. That's an issue about the clarity around confidentiality, perhaps more than a support person. Where a proposed support person has their own agenda and it comes out during intake, that's where you have that opportunity to either say that it's not appropriate or put very clear boundaries around the sort of role that they might have. And again, if the client accepts the support person's agenda and is willing to be influenced, that is the client's choice. And again, this is the challenge between us making a decision over their self-determination. If they want to do what the support person wants, maybe they have some sort of vested interest in keeping that support person happy, it's not necessarily a bad thing. If it's sort of undue influence, then that's probably problematic. But I think they're the things to consider. It's not a blanket reason to say no. It might be about setting clearer boundaries. Mika Brandon told me where she was doing a separated couple mediation and the ex-husband wanted to bring his new wife as a support person, and he insisted that Mika go and talk to the ex-wife about this, and Mika was really stressed about the conversation. So she was very tentative and nervous when she raised it with the ex-wife, and she said, oh God, yes, bring her along because she'll talk sense into him. She's so much more sensible. And Mika was like, but totally not what she was expecting. So I think that's also another example that sometimes who instinctively we think is the wrong person might actually turn out to be quite useful. This is the problem. Yes, probably in 98% of the cases, it's a sensible idea not to have the new partner in the room. But there are some situations where it can help, as we've just heard. So having some flexibility and not just having it at the discretion of the mediator, but having some guidelines, base that decision on, some sort of criteria. That's what I think we're missing in the field, and that I'd really encourage all of you to try and develop. I've done my kind of off the top of my head checklist, but I'm sure it's not the best. I'm sure that with all of your different experience in different contexts, you can improve on it and adapt a version that suits you. And let's be a bit open-minded about it. The people who we think might be problematic are not always, but if we don't ask the right questions, we're not going to know. We often make assumptions based on a person's role as the new wife or the union rep, rather than talking to the individual and talking to the client they're supporting and discussing the different roles and potentially the different agendas that they may have. And then not only is everyone clearer going into it, we know what sort of interventions we might need to have ready if people step outside those boundaries. I think in all aspects of our work, we can do more of that, because we do often tend to just do what we were taught, because we were taught by experts, we're taught by people who we admire, who are very good at what they do, but sometimes we don't ask enough questions. And one of my bugbears is that our facilitative model and our general accepted norms around it haven't changed in, I don't know, more than 50 years. And society's changed. I just think there must be some room for improvement here that we're missing. What we do works, but could we improve it? Could we make it more inclusive? That's my sort of big picture challenge for everyone. All right, everyone, thank you so much for coming. Feel free to reach out if you have any follow-up questions. And if you're watching on the recording, same goes to you. Feel free to reach out and ask any questions. And I hope to see you again soon. Thanks everyone. Bye for now.